Americans have the right to carry guns in public.
Second Amendment does provide an individual right to have a gun.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles.
This is a good bill. It'll protect and save lives.
The nation's highest court has ruled that Americans have a right to carry firearms.
Would respect that precedent.
Yes, Senator. All precedents of the Supreme Court have to be respected.
I don't think this was entirely a surprise that it came down this way, but it is potentially a momentous decision.
All right. The Supreme Court just handed down a unanimous 9-0 decision in United States v. Henderson, and I need you to understand what just happened here. Every single justice, all 9 of them, including Sotomayor, Kagan, and Jackson, just struck down 5 major categories of gun restrictions across all 50 states. This is not a drill. This is the most significant Second Amendment ruling in American history, bigger than the District of Columbia v. Heller, bigger than McDonald v. City of Chicago, bigger than New York State Rifle and Pistol Association v. Bruen. I'm going to break down exactly what this means for you, what changed in your state, and what you need to do right now. Here's why this hits differently than anything we've ever covered on this channel. If you live in California, New York, New Jersey, Illinois, Maryland, Massachusetts, Hawaii, Connecticut, Delaware, or Rhode Island, restrictions that have been on the books for decades just became unenforceable overnight. Permit to purchase systems gone. Extended waiting periods gone. Mandatory training. Prerequisites gone. Good. Cause requirements for carry permits gone. Discretionary denial systems where some bureaucrat decides whether you're suitable enough to exercise a constitutional right gone. And if you live in a free state, a constitutional carry state, don't tune out, because this ruling establishes strict scrutiny as the standard of review for every Second Amendment case going forward. That means every future attempt to restrict your rights at the federal or state level now has to clear the highest possible legal bar. This affects every gun owner and every future gun owner in America. The date is April 24th, 2026, and the constitutional ground just shifted under every legislature in the country. The Supreme Court said that the Second Amendment does provide an individual right to have a gun. States cannot put these special restrictions on getting a gun for a concealed carry permit. Core purpose of the Second Amendment is to provide law-abiding citizens with the ability to carry a gun for self-defense. Some of those more populous states, those states that require that extra hoop that you have to jump through, that's unconstitutional. Let me walk you through exactly what Chief Justice Roberts wrote in the majority opinion, because the language matters. Roberts held, and I'm quoting directly here, "The Second Amendment codifies a pre-existing right. Government may not condition the exercise of this right on permission, approval, or delay beyond what is necessary to verify eligibility. The default is liberty. Restrictions require the highest level of justification." Read that again. The default is liberty. That is now the controlling legal standard in the United States. The court applied strict scrutiny. And for those of you who aren't lawyers, let me explain why that matters so much. Strict scrutiny is the same test courts use for First Amendment free speech cases and religious liberty cases. It means the government has to prove 3 things. 1. There's a compelling government interest. 2. The law is narrowly tailored to serve that interest. 3. The government is using the least restrictive means available. Most gun control laws don't come anywhere close to passing that test, and the court knew it. Right now, military spouses are not considered residents to meet to be able to purchase firearms. There are people who travel around the country in RVs who today are not allowed to use a post office box. There are 140 sponsors for this. I am hopeful that this committee can bring this legislation up for action, a decision by the United States Supreme Court that recognized the individual right to keep and bear arms under the Second Amendment would respect that precedent. Yes, Senator. All precedents of the Supreme Court have to be respected. The decision in Henderson consolidated challenges to 5 specific categories of regulation across multiple states, and the court struck down all 5. Category 1 permit to purchase systems. States like Illinois with its FOID card, New Jersey, Maryland, Massachusetts, Connecticut, Hawaii, and Rhode Island all required you to get government permission before buying a handgun. The court said these are prior restraints on a constitutional right. You don't need a permit to speak. You don't need a permit to go to church. You don't need a permit to buy a firearm. Category 2 waiting periods beyond background check completion time. California's 10-day wait under Cal Penal Code, Section 26815. Florida's 3-day wait, Rhode Island's 7-day wait, all unconstitutional to the extent they delay transfer after NIC's clears. High Court this morning saying that Americans have the right to carry guns in public. The ruling is expected to allow more people to legally carry guns on streets of the nation's largest cities, Jersey, and other states. People calling up and saying thank you because it's ultimately going to affect us here. We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City. The court was clear. States can run background checks, but once that check is done, the firearm must be released. No cooling off periods, no arbitrary holds. Category 3 mandatory training requirements as prerequisites. States that required you to complete 8, 16, or even multi-day government-approved courses before you could get a permit or even own a firearm can no longer enforce those mandates. New York's Concealed Carry Improvement Act, the scrutiny that was passed after Bruen, had extensive training requirements. Those are now void category for good cause and proper purpose requirements. The few remaining may-issue jurisdictions, certain California counties, Hawaii, parts of Maryland, can no longer require you to demonstrate a special need for self-defense. Your need is the Second Amendment. That's it. Category 5 discretionary approval systems. Every permit system in America must now shall issue based on objective criteria. If you meet the legal requirements, age, clean background check, not a prohibited person, they must issue. No police chief gets to decide. You don't seem like the right type. Entities are being protected. We need to protect people. We need to protect people. This is a good bill. It'll protect and save lives. We should. I am proud to support this bill. I think we all should. Time is over for thoughts and prayers is amended. All in favor of the amendment as amended will say aye. Aye. Now here's the context that makes this ruling historic beyond just the holdings. We've never had a unanimous Second Amendment decision at the Supreme Court. Heller was 5-4. McDonald was 5-4. Bruen was 6-3. Every single time the liberal wing dissented. Sotomayor, Kagan, and Jackson have voted against gun rights in every major case. For them to join this opinion tells you something extraordinary happened. Gun control in these states had become so extreme, so transparently unconstitutional, that even justices who believe in broad regulatory power couldn't defend it anymore. And Roberts didn't write a narrow opinion. He established a framework that will govern every Second Amendment challenge for a generation. Strict scrutiny is now the floor. That means assault weapons bans, like California's under Penal Code Section 3.0515 magazine capacity restrictions, age-based purchasing bans beyond 18, and red flag laws without robust due process are all now vulnerable to challenge. Second Amendment Foundation, Firearms Policy Coalition, and other litigation groups are already preparing cases. The pipeline is full, and the legal standard just tipped decisively in favor of your rights. New York requires gun owners to give a specific reason they need to carry. The court said that violates the Second Amendment. We are the lawful legal citizens of the state. You know, most of us have training-sensitive places. Doctrine was not at issue in this case, and still exists. Now, let me be straight with you about what this ruling is and what it isn't, because I'm not going to oversell this. Henderson is a massive, historic, genuinely unprecedented victory, but it is not the end of the fight. Not even close. Here's what I'm watching. New York, New Jersey, Illinois, Maryland, Massachusetts, and Hawaii are already signaling resistance. They're going to try workarounds. They'll replace permit to purchase with mandatory free training that happens to have a 6-week waitlist. They'll replace waiting periods with slow-walked background checks they'll create. Shall issue systems with 20 objective requirements that are each individually defensible, but collectively create the same burden. We saw this exact playbook after Bruen, when New York passed the scrutiny, turning the entire state into a sensitive place where you couldn't carry anywhere. States that don't want you armed will find creative ways to obstruct. The difference now is strict scrutiny. Under that standard, workarounds are much harder to sustain. Courts will look at the cumulative burden, not just each individual requirement in isolation, but it will take litigation, it will take time, and it will take money. States like Texas, Florida, Georgia, Arizona, Tennessee, and the 25 constitutional carry states are already functionally compliant. They lose little or nothing from this ruling because they weren't infringing in the first place. Court strikes down a New York gun law, making it easier to carry a concealed weapon in public. Nation's highest court has ruled that Americans have a right to carry firearms in public for self-defense. I don't think this was entirely a surprise that it came down this way, but it is potentially a momentous decision. So here's where things stand right now and what you need to do if you're in a restrictive state. The permit to purchase requirement in your state is unenforceable as of this morning. Waiting periods beyond background check time are unenforceable. Training mandates are unenforceable, but your state hasn't updated its systems yet. Dealers may not know. Local police may not know. So step 1, know what changed? Research your specific state laws against the 5 categories Henderson struck down. Step 2, if you've been waiting to purchase or apply for a carry permit, now is the time. Get your applications in before states cobbled together replacement restrictions. Step 3, document everything. If a dealer or official tries to enforce an invalidated law document, it reported to SAVE for FPC, because those refusals are now federal civil rights violations. Step 4, support the organizations that will fight the workarounds, because they are coming. And Step 5, vote accordingly, because this ruling only exists because justices who respect the Constitution were on that bench. Oh, it's certainly a momentous decision. Unquestionably the biggest Second Amendment ruling in more than a decade from this court. We're not saying anything about a state that requires somebody to get a permit to carry a weapon. I feel proficient with my weapon, I feel secure with my weapon, and I feel confident with my weapon. Your rights. Just one at the highest level in American history. A 9-0 decision. Strict scrutiny for the Second Amendment. 5 categories of restrictions wiped out nationwide, but states will resist. And the next round of litigation starts immediately. Gun rights and the Second Amendment were front and center at the Supreme Court today. I think that someone who is not otherwise prohibited should be issued a concealed carry permit without any problems at all. It's thinking that, there's something not quite right here about what's going on. 2008, the court was divided over what the right in the Second Amendment meant. There is this balance between public safety and a constitutional right. I'll have a full breakdown next week on which states are complying, which are resisting, and exactly how to challenge officials who ignore this ruling. That's it for today, folks. See you in the next video.